delighted to have two panels today. Each member of the committee will have an opportunity to question one or both members, either a 5-minute round of questions with our first, with either panel, or 3 minutes with both. And on the first panel, we're going to hear from the Honorable Mark Gordon, who is Governor of Wyoming. On the second panel, we will hear from Lisa Pretty, who is the owner and operator of the JB Ranch, and Jamie Rappaport Clark, who is President and Chief Executive Officer of Defenders of Wildlife, and she'll be joining us remotely from Leesburg, Virginia today. Now, I want to remind the witnesses that your full written testimony will, of course, be made part of the official hearing record today, so I'd ask that you please keep your statements to 5 minutes so we'll have plenty of time for questions. And I know we do have a roll call vote on the floor of the Senate a little later this morning. First, I'd like to introduce Wyoming Governor Mark Gordon, who has been serving as governor since January of 2019. Governor Gordon grew up on a ranch outside of Kaycee, Wyoming. He worked there after graduating from college. He then started his own ranch, as well as several successful outdoor recreation and tourism businesses in both Buffalo and Sheridan, Wyoming. Today, Governor Gordon and his wife Jenny own and operate the Merlin Ranch east of Buffalo, which has been recognized by the Society for Range Management with the Excellence in Range Stewardship Award. Prior to his election as governor, he served as Wyoming's state treasurer from 2012 to 2019. Governor Gordon's efforts to improve the state's financial portfolio resulted in Wyoming being ranked #1 in the country for transparency. Governor Gordon's service to Wyoming does not stop there. He has served in a variety of other positions, including as member of the boards of the Wyoming Wildlife and Natural Resource Trust, the Nature Conservancy in Wyoming, the Wyoming Environmental Quality Council, and the Powder River Conservation District in Johnson County, Wyoming. I hope that Governor Gordon will tell us about some of his experiences in Wyoming, balancing the interests of citizens while effectively conserving and recovering wildlife. Governor Gordon, it's a great honor to welcome you again as a witness before the Environment and Public Works Committee. I want to thank you for traveling to Wyoming, from Wyoming to Washington today to be part of this hearing. Governor Gordon, please proceed.
Thank you, Mr. Chairman, Ranking Member Carper, and members of the committee. When I last had a chance to be before this committee, we were a lot closer. But I thank you very much for this opportunity to testify on Senate 4589, amendments to the Endangered Species Act. I am the 33rd governor of Wyoming and the third in succession to support such a bill. Governor Freudenthal, that Senator Ranking Member Carper mentioned, is a Democrat and a friend. He was the first. Governor Mead, a Republican, also a friend, and my immediate predecessor, both suggested improvements like those contained in this bill. Unlike them, I am not an attorney, but we all share a love of our state and its remarkable wildlife, flora, and fauna. I was remembering as I came here yesterday that a year ago I was with game and fish biologists as they were logging and collaring a male grizzly bear that had gotten into some trouble in Sunlight Basin. For some of you, Sunlight Basin is familiar. It's a beautiful valley just east of Yellowstone Park. The Clark's Fork runs through it, the same river where the Nez Percé, led by Chief Joseph, made good their escape from pursuing armies. This particular bear had gotten into trouble for killing a horse in someone's pasture, and therefore needed to be relocated. I remember that experience as being especially meaningful because back in the late 1970s and early 1980s, I had worked as a citizen environmental leader to help recover the bear after Yellowstone Park's dumps had closed as a tourist attraction. At the time, there were fewer than 150 bears in the area. Not many bears. And for a couple of generations, their lives were transformed immeasurably. But they have subsequently learned new behaviors. I am a rancher, one of 9 who signed up in 2014 for the first candidate conservation agreements with assurances inside a tent with Governor Mead and former Secretary of Interior Sally Jewell. It took place on a windy hill outside of Pinedale, Wyoming, and the ceremony represented the culmination of many efforts between Wyoming governors, landowners, industry, and the federal government to find a strategy that would protect the sage grouse and enhance core sage grouse habitat because that is essential to protecting the bird from extinction. In turn, as we have learned more about this fascinating bird, I have issued my own executive order recently to improve on this approach, which began 2 administrations ago, involving private landowners, government agencies, non-governmental entities, industry, citizens, and all with the common aim of protecting the largest concentration of remaining grouse habitat in the country. It's working. Northeastern Wyoming sage-grouse populations have improved of late, something that I can attest to from seeing the birds in my own hall pasture over the course of the past year. I digress to point out my personal experience with the Endangered Species Act from many sides of its implementation. And while I must acknowledge that there are many aspects of the Act which can be problematic to private property at times, misinterpret science, and at times be used improperly, it is nonetheless a well-intentioned law with a laudable aim, an aim which it has sometimes failed to accomplish. Members of the committee, I come to you today because I believe the Endangered Species Act is broken and there is no scientific reason it shouldn't be fixed. This bill amends the Endangered Species Act in necessary ways that are intended to bring more transparency, better cooperation and incentive, and that most key element of empirical science, the ability to test a hypothesis, correct for undesirable outcomes, and chart a clear course to species recovery. Wyoming provides a multitude of successful examples, from species recovery to preventing species from being listed in the first place. Unfortunately, Wyoming also has a long history of being hamstrung with paying for species management, yet being obliged to defer to federal government on decisions about that management. This is particularly vexing when species have fully recovered, yet remain listed because of legal horseplay and judicial jousting. Rather than focusing on actual results, courts are asked to speculate on what-ifs that lead to a vicious cycle. On the side of those charged with finding solutions, they face unending expense and never-ending challenges, while well-meaning gadflies take advantage of a golden goose that lavishes court costs and legal fees and provides a fundraising cash cow. Neither the species nor affected parties find much relief in that recipe. This is not how the work. Wyoming is home to several lightning rod species. Species like the carnivores that command national and international attention. The gray wolf and the grizzly bear have a marquee value that is mesmerizing. Perversely, some organizations who set forth to do good work found the fundraising appeal of these stars irresistible. While dire threat once underscored urgency, now the work of resolve these issues falls to more routine issues arising in areas where large carnivores come into conflict with humans, domestic livestock, and big game. That process can seem more mundane, taking up the cudgel that the Endangered Species Act has become to impose the will of the federal agency, often to the detriment of affected parties, seems to be more compelling. Let me mention a few examples of why the ESA needs fixing. The gray wolf was reintroduced in Wyoming despite objections throughout the state. After 5 lawsuits and 15 years, the wolf was finally delisted. Scientific research and rigorous study proved to us that the wolf had reached the recovery thresholds that had been set for it for 10 years before that finally happened. Today, under our management, the population is thriving and expanding well above federally required population objectives. Another successful recovery, by all accounts, is that of the greater Yellowstone grizzly bear. It ranks as one of the most significant conservation success stories in. And I will tell you why. When a retired judge wakes up to find grizzlies on his back porch in downtown Cody, 52 miles from Yellowstone Park, or even further on, 47 miles away in Cowley, Wyoming, a farmer's corn maze needs to be shut down last year because grizzlies are in it, it is pretty evident bears are expanding and thriving too, well beyond government objectives. But this example of recovery is also an example of the Act's reluctance to delist. We know more about the grizzly bear than any other wildlife species on the face of the earth because we have studied it extensively since 1975. In all that time, we have seen methodologies and technologies improve. Our ability to estimate populations, migration dynamics, behavior, and so on has evolved even as challenges facing the bear have also emerged. Wyoming is proud to have paid for and taken an active role in grizzly bear recovery and management for over 4 decades. Wyoming hunters and anglers financed the $50 million investment in grizzly bear recovery. When I started working on environmental issues back in 1979, the population was estimated to be around 136 bears. They were in peril, no question about it. Now, the most conservative estimates run between 700 bears on the low side and as many as 1,200. The population is recovered to a point where it is the Wyoming people who have changed the way they work, live, make their livings, and recreate in bear country. More human-bear interaction means there are more bears doing more things that involve people. These incidents, some tragic, provide further proof that the bear has recovered and management must evolve beyond its initial objectives. Despite the species being fully recovered for 20 years by every milestone that has been set for it for over those 40 years, the bear remains listed not because there is some novel or unaccounted for threat, not because there is some scientific concern over the population's viability. It remains listed because twice federal courts have rejected meticulously crafted U.S. Fish and Wildlife rules. In both cases, the court delved into complex and sometimes unsettled scientific findings, as well as policy decisions of the Fish and Wildlife Service, looking for what-ifs to scuttle the delisting. The court seemed to ignore the findings and conclusions of grizzly bear experts in favor of ruling in a way that simply reaffirms a status quo. Perhaps it should come as no surprise or coincidence that 5 of the 6 lawsuits challenging the most recent 2018 grizzly bear delisting rule were filed in the same district court, a court where previous eco-activist-backed suits had found success. That is what we apparently do these days: shop for judges favorable to one's point of view, regardless of law or evidence. Wyoming spends around $2 million annually to manage grizzly bears. That's the state's money, not federal reimbursement. Grizzlies are federally protected species, yet the state of Wyoming bears much of that cost. An obvious question is, why are we unable to manage the bears when we should be shouldering so much of the cost? For these reasons and many others, I support the bill before you today. These amendments will align the act with its original intent to protect imperiled species, recover them, and remove them from the threatened or endangered species list. My predecessor, Governor Mead, opined before this committee a few years ago about better ways to serve listed species and get them to what should be the goal of the ESA, delisting. His suggestions were supported and crafted by the bipartisan Western Governors Association. They are sound. To my view, the largest barrier to delisting and returning the management of fully recovered species to the states and tribes is litigation. Not litigation based on whether a species is recovered, but litigation aimed at finding technicalities in how the United States Fish and Wildlife Service promulgated the rules in the first place. Thus, I believe this bill's proposed delay of judicial review during post-delisting monitoring is essential to its success. This provision will not harm species conservation. Rather, it will provide states and tribes a reasonable period of time to show whether their management plans work. This approach properly comports with the scientific method. In any case, this bill still provides substantial safeguards, allowing for greater federal involvement should that be deemed necessary, including emergency relisting. There is a safety valve. Giving states an incentive to implement state management plans will work. Keeping the big stick usually used to hit states over the head via litigation at a reasonable distance will incentivize state-led conservation efforts. Wyoming has invested in conservation for listed species, even in the face of multiple legal challenges. We have shown our commitment and our ability to find success with the Wyoming toad, the black-footed ferret. We are proud of that heritage, and yet public support of this type of investment could wane with the continued frustration that has come at the hands of pickers of nits. Critics of amending the act may say that states don't want to conserve at-risk species or that states lack capacity and expertise. Nothing could be further from the truth. The majority of wildlife in our nation is managed and managed well by state and tribal governments. The public trust doctrine outlined in the North American model of wildlife conservation is the bedrock for wildlife conservation in our country. It is also worth recognizing the substantial contributions made by private landowners, ranchers, and farmers across our nation to wildlife conservation. To have those efforts overturned by litigation early in process is a great deterrent to cooperation. Further considerations, including takings, are not insignificant, and they also deserve a fair hearing. This bill provides a thoughtful way to address these complex issues. The current bill significantly improves on this Bedrock Act by encouraging state and tribal involvement throughout the ESA process. It provides requirements for the Secretary to notify governors when an ESA petition is filed. It provides allowances for state agencies to lead recovery teams and to take significant roles in recovery planning and implementation. It provides governors and tribal leaders the opportunity to weigh in on listing decisions before it is too late. These are critical steps, recognizing the value of local wildlife managers and what they bring to conservation and recovery of imperiled species. Most importantly, it provides an early entry for state and tribal governments, as well as citizens and those affected, to help define what recovery looks like. Almost 30% of the species listed under the ESA have no recovery plan. A problem. How can a state, federal, or tribal government meet the intent of the Act and help recover imperiled species if they don't know how recovery will be defined?
Governor, we're so grateful for your passion. I know we have a number of senators that want to get to ask specific questions. So I don't know if you could wrap up so we could get to those.
Yes, thank you, Mr. Chairman. Forgive me for my excessive time. Very much appreciate this. I do want to make one last note, which is that I think the funding that this bill brings is extraordinary and will be very helpful to state efforts. As I mentioned in my testimony, the big challenge here is that the state bear the burdens of the cost.
Well, we are so grateful for your thorough, your excellent presentation. We do have a